Hello and welcome to Parley, the Hindu's weekly podcast where we explore pressing questions of public interest with insights from leading experts. I'm Aaratrika Bhaumik, your host for today, and the question that we're asking this week is: are existing institutional mechanisms effective in preventing custodial violence? The gruesome death of 27-year-old security guard Ajith Kumar while in police custody in Tamil Nadu last month is yet another grim addition to the long list of custodial deaths in India. The extent of his injuries was so severe that the Madurai bench of the Madras High Court was compelled to remark, and I quote, "Even an ordinary murderer would not have caused this much injury to a person." Meanwhile, Chief Minister M.K. Stalin has ordered a CBI investigation to ensure a transparent probe. The High Court has also directed the agency to complete the investigation and submit its report by August 20th. To examine the persistence of police brutality and the glaring lack of accountability mechanisms in such cases, we are joined today by Dr. M. Srinivasan, Professor of Criminology at the University of Madras, and Dr. Anup Surendranath, Professor of Law and Executive Director of the Square Circle Clinic at NALSAR University of Law, Hyderabad. A very warm welcome to the two of you to the pod.
Thanks for having me.
Now,
Thank you,
Dr.
madam.
Surendranath, I would like to begin the discussion with you. Now, we have statutory protections in place when it comes to custodial violence. We also have years of jurisprudence where the Supreme Court, as well as bodies like the NHRC, have laid down guidelines. Why is it that we still see such cases happening on a routine basis even now?
Thanks, Aaratrika. Thanks for having me here today. As you rightly said, I think pretty much everything that has to be said in terms of Supreme Court jurisprudence has been said. Of course, legislatively, India has really not implemented the Convention Against Torture, even though it has not taken forward its obligations under the Convention of Against Torture. So, of course, there is a legislative gap and there is a lack of political will in bringing that international obligation into effect. But even if that were to be brought in effect, I think the larger problem is that there's a certain institutional culture of justification of custodial violence, both from within the institution and also outside the institution. I think there's repeated work on this saying that the police often view their own role as justified in engaging in this kind of violence. It's sort of seen as perpetuating justice in an efficient, effective manner and not subjecting it to the slow process of the legal system. So there's almost a sense internally that what is being done is justified. And of course, externally, I wouldn't think that there is a public culture that takes the view that custodial torture and custodial deaths is unjustified in all contexts. You can see that the reaction is very case specific. If you can contrast the reaction to the Bhaumik case as opposed to what happened in Hyderabad when 4 individuals accused of raping and murdering a young woman were concerned, there was celebration in one, outrage in the other. But I think there is no public culture of saying that in all instances, public custodial torture and custodial deaths needs to be condemned. So we are not even dealing with a situation where there is absolute condemnation of such violence, either within the institution or within the media or within our public discourse. And I think that really is the challenge. This apart from, it's almost impossible to get accountability within the criminal justice system for perpetrators of such violence. It starts with not enough recording of such instances. There is no authoritative record of this. I would think that even the NCRB statistics on custodial deaths is not representing the true picture. NCRB statistics don't have anything on custodial torture. And even if in cases that people want to pursue this, there are so many institutional barriers in trying to get accountability that it's so rare to hear about such cases. And there's absolutely no support. They are subject to so much pressure and to take back the cases, and they really get no support in accessing justice, the families of the victims. Yeah.
Right. We'll get to the lack of accountability measures a little later that you have flagged. But before that, I mean, do you believe that a standalone law on torture is a solution? In specific, what my understanding is that since we do not have a specific definition of torture, and what Supreme Court in its judgments, it's a pretty high threshold that the Supreme Court has laid down. For example, it uses the word force resulting in serious injuries or custodial death. So, I mean, it kind of does not take into account, let's say, psychological abuse or forms of physical abuse which leave no visible marks. So, do you share these concerns? Do you think that we have to define torture first for real accountability?
I think it's essential, but just having a separate law that has a meaningful and substantial definition is it's essential, but it is not just all that is required. Of course, as I said, we've signed the United Nations Convention against torture, but we haven't ratified it. And I would certainly think that a specific law on torture would help. But Aaratrika, my view would be that we cannot just legislate away problems, right? Even if we were to have a great law that everyone felt had the proper definition of torture, it had the proper procedures, I think institutional cultures and the institutional capacity and institutional attitudes, both within the police and the court system, are far bigger challenges that we need to address. Of course, all of those problems are compounded by not having a proper law. But I would also think that even if we were to have a proper law, these larger institutional and cultural problems are going to be much more difficult to solve. And even if we had the law, we'll continue seeing these happen. Yeah.
Right. Dr. Srinivasan, coming to you, of course, Dr. Surendranath mentioned that we have this pervasive institutional culture where police brutality is often celebrated amongst the police forces. So, according to you, what are the factors that contribute to this?
Before we discuss the police culture or police subculture, I would like to add what Professor Surendranath said. For instance, you rightly asked about the institutional mechanisms, and we do have actually, in fact, of course, I do agree with him that India has not ratified the UN Convention, but still, we have very also like the constitutional provisions which protect the human rights of the accused as well as the offenders. We have, of course, 1997 DK Boss guidelines. We have provisions in the previous Code of Criminal Procedure, now Section 36 and 37 of BNSS. All these things have, if these provisions are strictly adhered to, I think we can definitely stop. Even we can, without even ratifying the UN Convention. For example, like one of the simple practices, all police stations should prominently display the rights of the arrested person. It won't take much time or money, but still we are not able to realize that simple guideline laid down by the Supreme Court of India. Installation of CCTVs in all police stations. And no deviant police officer or personnel is punished. For example, 2022 NCRB statistics says all over India, 41 cases of custodial deaths were reported, and 12 cases were registered. And if you look at the outcome of all those cases, not even one case, neither the charge sheet was filed nor they were convicted. And it becomes a mere coward. It doesn't serve any purpose. It is not, as he rightly said, like the law cannot be the solution, actually. To what extent do we strictly adhere to the rules of the rule of law? That is very, very important. And we also have another interesting fact is that if you look at the speed at which the police complete the investigation, if you take again, I don't have much statistics. I mean, the latest statistics, of course, NCRB has not published after 2022. If you take previous statistics, charge sheeting rate is very, very high, 95% plus. It shows that police hurriedly complete investigation by employing all methods, including third-degree methods. when it comes to the conviction rate, it is, for instance, in the case of insult to modesty of women, erstwhile IPC 509, it is 27.1 in few years before. So it shows that it doesn't serve any purpose, like due to the pressure or due to like the seniors pressurize these police officers to hurry up the case, whatever may be the reason, but it doesn't serve any purpose. They complete the investigation, file the charge sheet. At the end of it, we are not able to punish the wrongdoer. That is a reality. And as Professor Surendranath also said, police, I would say, like what factors that influence police culture, that includes hierarchical structure, that includes working environment, that includes public perception too. And this particular behavior, police behavior, is also reinforced by media and indirect approval of the behavior of the public too. So that is also another important factor that, I mean, we don't condemn or we don't disapprove the behavior of the police or policemen.
Right. In fact, we have movies also which glorify vigilante justice on such a large scale. So I'm sure that also has a role to play in this institutional culture that we have at present.
That's more important. Maybe when you ask the next question is all about training. Training also, like, it should be a continuous affair. It is not one time. They do conduct training programs at all academies, police training colleges, or police schools. But still, when it comes to the practice, they become part and parcel of the police organizational culture. As I said, like, there are certain factors which determine or decide their behavior, and that is obviously reinforced by both by the public as well as by the media. And it's again, we need to concentrate on the public discourse. A violation of human rights at any point of time be justified. We can never justify whatever may be the reason. Okay, that's what even Supreme Court 1997 clearly observed and gave direction. And we are not, after almost nearly 30 years, we are not able to realize or put in practice what the Supreme Court said then.
Right. Thank you, Dr. Srinivasan. Dr. Surendranath, coming to you, if we were to look at the effectiveness of these guidelines of the Supreme Court, in specific the guideline to have CCTV cameras in all police stations, as well as the right of victims and their families to access this footage. I'm talking in specific to the 2020 judgment of the Supreme Court in Paramveer Singh versus Baljit Singh. Based on your experience, and of course, you head an organization which closely work with victims of custodial violence. Do you think, what is the ground reality? Do you see these implementation of these measures?
Yeah, I'm glad you asked this, Aaratrika. The CCTV judgment in Paramveer of 2020 is a classic example, right, of what the court thinks are technocratic solutions to institutional problems, right? So they said, okay, let's have everyone install CCTVs, right? Of course, nobody knows how many of these CCTVs have been installed, where have they been installed, have those guidelines on where they need to be installed has been done. So compliance itself is a problem, which we don't know. And okay, let me just leave aside the compliance issue for now. Even if there were compliance, right? What is such a classic script, which is also has happened in Ajith Kumar's case, is that the sites of torture are very often not the police stations, right? And even if you were to ensure that they installed CCTVs, the CCTVs are functional, CCTVs magically, when you want to see the footage, they're suddenly gone out of functioning. Even if we were to avoid all of those issues, as you've seen, there is undocumented detention, there is illegal detention. The date and time of the arrest is shown as something else. In reality, it would have happened many hours or days earlier. So illegal arrests and illegal detention is a stark reality of our system. And the documentation often starts in terms of formal police records, often starts after the person has been arrested and tortured illegally or wherever else. And as has happened in this case as well, right? In Ajith Kumar's case. So, how do we change those problems, even if these guidelines were complied with? And even in the US, they said, okay, let's have body cams, right? Cops have to wear body cams. Even that is no solution to the kind of custodial violence that we have seen, and so many profound and tragic cases coming out of the US of blacks being killed, right? So in that sense, that really forces us to say that the law can say whatever it wants. And as far as the Supreme Court is concerned, I agree that pretty much what has to be said has been said, but we really need to worry about political will and institutional capacity to take these forward, right? And I'm not here anyway advocating that we need to just view this as a question of bad apples in the system, right? Or these are just evil people in the system kind of thing. I think it's a far more complicated issue than that. I think institutional practices encourage or make such behavior inevitable. The how our police officers our police persons are selected, how they are trained, their service conditions, how modernized our police forces, right? All of that, and largely we still fundamentally, once you strip away everything, at the core for me, the problem is that we are still in a colonial mindset with the police, where our own people are our enemies, right? We view as these are bodies to be certain bodies, not all bodies, may I add, right? Certain bodies are game for control. They need to be controlled. They are suspicious. Anything can be done with those bodies, because that is seen as the purpose of policing. It is not seen as any aiding a population or helping a population. It is seen as a force to control a population, right? And as long as we are in this control mindset, we are going to perpetuate this kind of violence. There is no escaping that, right? And changing that culture is an uphill task. Yes.
Right, right. And like you mentioned, that, in such cases, direct evidence is very hard to get. Mostly you have police officers who are called to testify, and they would never incriminate their colleagues. Now, a recommendation from the Law Commission of India, and this has been recommended twice, is to have a provision where there is reverse burden of proof in such cases. Do you think this could heighten accountability?
Absolutely. I don't want to be mistaken as saying that the law does not matter, right? At the risk of repetition, I just want to say the law, even if we were to have ideal provisions like a separate law on torture or the reverse burden of proof by amending the relevant provisions in the evidence law, right? All of that are helpful and are necessary. I certainly think that, rebuttable presumption in the evidence law would be of great help. But Aaratrika, even if that were there, my question for us to think about is that how are individuals going to access this? First of all, we must understand that people who are subject to such brutal police violence and even ending up in their deaths, right, are extremely vulnerable populations, right? Either by caste, class, or religion. These belong to the vulnerable sections of our society, and that's on whom this violence is perpetrated, right? And in those cases, how are we empowering them to pursue these legal and constitutional remedies? Just having these remedies in and of themselves in a system like ours doesn't ensure that people can access them. How much will you expect people to leave aside their daily livelihood questions and go around chasing these things in court, right? And our court really tests the persistence and the survival of litigators in a system like ours, right? And so my point is, even if we were to bring in the law or change the evidence law, the capacity to pursue justice is a huge mountain to climb for us.
Right, right. Dr. Srinivasan, I would like you to respond to what Dr. Surendranath mentioned, especially that, the police force in our country, they're seen as a medium of oppression. They are not to aid the population. That seems to be the attitude and the behavior that we see in police forces. What do you think? What changes are required, let's say, in their training, so that, there is at least an attempt to change this pervasive culture?
Before I come to that question directly, If I'm permitted to just two lines use and D.K. Basu, they said like torture has not been defined in constitution or in other penal laws. Torture of a human being by another human being is essentially an instrument to impose the will of the strong over the weak by suffering. That's more important. So on whom the police show their power? They show the power on the powerless. If you look at just to take the sample of cases, it is not an all accused or all suspects. It is third degree methods are used only on the petty offenders, more particularly property offenders. Other offenders, you don't come across, say, for example, a white collar criminal is abused at police station or any other place of custody. So that you have to keep that in mind. And here again, when you want to get any information from the suspect or accused, we don't need a very sophisticated forensic tool. And simple scientific interrogation techniques are sufficient. Unfortunately, our police, they don't believe in science, or they don't believe in taking the support of psychologists or forensic psychologists or other experts. And though they are trained during their initial training, and they don't update themselves, and they are not equipped in terms of, updating the interrogation skills. And that's what Supreme Court rightly said, that you cannot use your power on the powerless. They are totally powerless. They are under your custody. Why should you again even think of using your simple force? That is, at no point of time you can justify that. Point one. Point two is that when you talk about who is a victim of abuse of power, very beautiful words from the UN Declaration on the Basic Principles of Justice for Victims of Crime Abuse of Power, way back in 1985. They said like it need not be. I just read out again. A victim of abuse of power means persons who individually or collectively have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts or omissions that do not yet constitute violation of national criminal laws, but of internationally recognized norms relating to human rights. So that's more important. In your country, it may be a regular practice, using your force on the powerless, on the property offenders. But there are certain internationally recognized human rights standards. They keep setting the standards. And we don't have any reference also. And no document says, okay, these are the internationally recognized norms. But those norms, those standards keep changing as we progress, as human society progresses. And these standards also progress. And we are supposed to be more humane and more, we have to treat other human beings as human beings, irrespective of whether they are accused or suspects or offenders. So that's what my point I want to underline. And it is a kind, need not be again, it is not due to lack of training. It is not definitely not due to lack of training. It is due to lack of insensitivity to the pain and suffering of the other individuals. So I want to emphasize on that. So it should be a part of the police subculture and police organization culture. They should be told every day. Every day it should be part of their discourse and discourse of the public, and it should be a general discourse in society that, okay, don't harm other human being, irrespective of who he or she is.
Right. Right. Dr. Srinivasan, of course, you've mentioned international standards, international best practices, but do you agree with what Dr. Surendranath is mentioning, that despite these standards and despite, there is a lack of political will that we see, which I think is the root cause. Do you agree with this?
I don't say it. We again try to like simplify things and saying, shifting the blame on the political masters or the ruling class or the state. It is again the police. They should own up the responsibility. I think the police officers at each and every level, like the police station level, and they are not afraid of all these violations, and they are encouraged sometimes, or those errant behavior is also ignored, and that's what again ignored sometimes, or other way, like they are also encouraged, or that kind of behavior is also reinforced through various media, including simple social media or films or television serials, or any even public perception also sometimes support such kind of violent or deviant behavior. And one of the authors, if I'm correct, they say like an individual can become violent, an individual can become a criminal or a deviant. The state or state agencies or state cannot become violent. State should be so civilized, so sophisticated to deal with its citizens. I think that kind of philosophical understanding should be there, and the system should be sensitized. And we cannot say it is not the policeman's behavior at the local station, and it need not be a reflection of the performance or of any particular state government or the state. I would say they have to own up the responsibility at the ground level.
Right. Thank you, Dr. Srinivasan. Dr. Surendranath, if we could now discuss a little about the important role that judicial magistrates play, especially as the first line of defense against police excesses. Now, again, we have a lot of statutory provisions as well as Supreme Court judgments which say that, magistrates have to apply the judicial mind when considering remand into police custody, as well as they're obligated to conduct a physical examination of the accused at the time of first production. But do you see these actually in practice, these implemented in practice?
So we had done when we were formerly the Project 39A, we had done a study on magistrates in Delhi and constitutional protections. It's a study led by Ginny Lokanita and Zeba Sikora that was done for Project 39A. It is so revealing as to how very fundamental constitutional protections are translated into what are known as first productions that you are supposed to be produced before a magistrate after 24 hours of the first 24 hours of police custody. It is such a significant site for implementing very basic constitutional protections, and the manner in which it is flouted is really stunning. Even in a place like Delhi, that this is what is happening in our magistrates' courts, that how perfunctory these first productions are, how magistrates don't really perform the role that is envisaged for them in terms of looking at, hearing how the arrest took place, what has been done to them in custody, speaking to the arrested person, trying to elicit information from them about how they've been treated in custody. None of that happens. Even the medico-legal examination, the documentation around that is such, so it's just seen as a matter of just ticking boxes in a form. Does it exist or not? There is no meaningful engagement with that procedure to see if this person has been subject to torture or not. And that is the most important time and place to see whether the police are engaging in that kind of behavior, so that if they are, they can be held accountable, or most importantly, this person is not sent back into police custody, right? And barely is there a lawyer present during these proceedings, right? Because it is seen, the judicial system functions as though this is just a routine procedure. Yes, you have to just tick these boxes, and this person has to be sent to further police custody or judicial custody. And unfortunately, the most basic of constitutional protections are in the hands of this system of first productions. But our findings really showed that how barely anything of it happens in these first productions. Yeah.
Right. And also, I mean, of course, we have seen lapses when it comes to how these judicial magistrates conduct such proceedings. Do you think there is also, do you think the higher judiciary has also fallen short in making sure that there is accountability for such lapses?
I mean, first is that, how efficiently are these cases being prosecuted, right? And what does it mean to prosecute cases of custodial torture and custodial death? I think we just haven't done enough work on highlighting the barriers on accessing justice, right? But more importantly, from a doctrinal perspective, in terms of positions of law, right? I think the higher judiciary's biggest failing has been, what is the consequence of, even if such treatment were to be established, right? When I say treatment, that this person has been subject to custodial violence, right? What is even to a case, right? What is the consequence of that? We can't just treat this as in terms of, okay, will you get a compensation or not? or will the police officer be prosecuted or not? Doctrinally, I would think there has to be a consequence for whatever this person has been arrested for, even on whether how you are able to prosecute that case any further or not. Such treatment must have a bearing on that. Unless appellate courts start taking a strict view that any incidents of custodial torture or custodial violence will have a bearing on whether we are willing to convict this person or not, this is not going to change. You have got to make consequences pinch for the prosecution and the investigation, right? As of now, they are like, okay, these are separate procedures. We will see if this person files another criminal case against us or will pursue compensation or whatever, right? And in our work that we've routinely seen how torture based evidence enters into cases, either through recovery evidence or through confessions. It is shocking the amount of torture based evidence that comes into our criminal trials. And a big culprit in this is the manner in which, in the previous the erstwhile evidence law, section 27, how recovery evidence is allowed, right? And that provision is the backdoor entry for torture based evidence, right? And we'd be quite shocked at the extent to which we don't of course call it torture based evidence, but in effect it is torture based evidence that informs so much of our conviction rate. If section 27 were not there, and that is why the system allows the section 27 recovery evidence, right? Because you rely so much on these methods of torture to generate evidence, because very often it is generating evidence, right? And if we didn't have that provision, even the current conviction rates that we see would not be there. And the system is worried about that if we suddenly say, recovery evidence is not, we are going to be skeptical about recovery based evidence, then what will happen to the already abysmal conviction rates, right? And therefore then you live with a system which allows torture based evidence through the back door.
Right. Thank you, Dr. Surendranath. Dr. Srinivasan, coming to you, of course, you mentioned earlier that the current reward as well as the promotional structures that we have within police departments, in so many cases, we have seen that accused police officers have been promoted. So we have this culture, of course, we've discussed that in detail. Do you think, let's say, that is what some experts advance, is that the principle of command responsibility, where you have higher police officers being held responsible for the conduct of junior police officers. Do you think something like that would work in the current police force that we have to enhance accountability?
But I don't think that will work. And they should be told, actually, they should be taught also at the ground level. They have to simply follow the rules. And it need not be, fixing accountability will not resolve any problem. And they should be punished, actually. In fact, if they become deviant, if they violate the rules, they should be simply punished. And for that, I think a person who's involved in that behavior should be fixed. And it's not simply fixing the accountability. For instance, I think law is very clear that in all cases, you need not arrest the accused or suspects, right? So arrest should be the last resort. It's very clear, as even the CRPC clearly says, S12 CRPC, now BNSS. Why should these people simply take a person to the police custody? So that should be first, there should be a mechanism which can check. Again, CRPC, BNSS is very clear that the procedure is clearly established. Clearly, you have to simply follow those procedures. If they follow, I think there will not be any violation, and the supervisory officer should check whether these provisions are strictly followed. And very often they give justification, yes, no, due to pressure, due to we are answerable to the officers or to the political masters, and those justification, those reasons cannot be justified. So we should, make them to feel, or they should be taught that you please follow all the rules. And we are not asking them to follow which are not there on the rule book. Right? That is the first thing they should do it. And second thing is there's a continuous and consistent sensitization on the human rights issues, and right from the top to the lower level policemen. So that should go on actually regularly by all agencies. These two should go parallelly besides other steps. And if you ask as a professor of criminology, we go one step ahead and say that there are some, scholars who have written that we can even go to the extent of decriminalizing these property offenses. So it was once upon time, all these property offenses were considered as intentional tort. And we even advocate that that's again, we are far behind all those ideas, at least ideas level. And we at least now think in terms of treating these people as per what law says. That's we have to ensure that, and who should be fixed, or that the question doesn't arise. Actually, the accountability alone is not enough. A person who indulges in such violence should be punished as per the law.
Right, right. Thank you, Dr. Srinivasan. Dr. Surendranath, coming to you. So, in the judgment of the Supreme Court in Prakar Singh versus Union of India, the Supreme Court was aware that you be required independent institutions when it comes to addressing complaints against police forces, which led to the creation of the state and district police complaints authorities. How effective do you think such watchdogs have been until now?
I think, it is a great example of non-compliance and what, the court almost there are these areas where the court has said so much and where there is hardly any compliance, right? The complaints mechanism that you're talking about has hardly been implemented. Very few states have really acted on it. And I think it speaks something to the area in which we are when you're talking of custodial violence and police action, how little the courts are able to force the hand of the governments, right? And repeatedly, and there's a long history of, in these areas, the courts saying the right things and laying down guidelines and trying various measures and hardly receiving any compliance from the states, right? But the really question was, why is the court so patient with it, right? And why aren't the courts insisting that they be implemented and followed, right? And that's where it starts to really get a little worrying, to be honest, that maybe the system doesn't view this as, yes, in the level of rhetoric, of course, it says the kind of things it has said. It's really the worst kind of thing to happen. These are terrible human rights violations. It says all of that, but I don't think it walks the talk, really, right? Neither the court nor the government institutions and those the processes that we have. I don't really see them walking the talk on many of these issues, and that really shows, for me, the point that I was making earlier, that ultimately I think these are dispensable bodies, right? And if it were another category of offenders or something, we wouldn't see this, right? And we need to confront that reality here, right?
Right, right. In fact, when I was researching for this, so the Maharashtra came out with this law, Maharashtra Police Amendment and Continuous Act of 2014, to basically implement this judgment. And when you see how these authorities are functioning in Maharashtra, in these bodies, you're supposed to have independent members, you're supposed to have retired judges. Instead, in Maharashtra, you have serving police officers in these bodies. Second, recommendations of these authorities are supposed to be binding on the state government. Now, there is a provision which has been enacted in the state legislation which says that in certain circumstances it will not be binding if the government can provide reasoning. So you also have these state governments kind of bypassing these guidelines mentioned in the judgment, which of course brings us to what you've been talking about, that there is a lack of political will and there is no real accountability. And of course, we don't see the Supreme Court or the higher judiciary really even address such lapses. Right. Proceeding to the last question for the evening, Dr. Srinivasan, do you see the potential in community policing or increased civil society involvement when it comes to curbing such practices?
Yes. Yes, definitely. Civil society involvement. I think we need to define where is that civil society, who will be involved in this particular process, whether the elected representatives of the local governance. All those questions should be clarified before we talk about the involvement of civil society in this particular process. Again, community policing, again, it changes. It's a relative phrase. How we look at in the Indian context is different from how it is being operationalized in the countries like UK and USA. There is a full involvement of the community representatives in the entire policing. Here we don't have such mechanism. Again, we have some representatives like the people they can join, and they are not fully trained, and they cannot be involved in the policing job actually. So, but the community and the police should be made answerable to the representatives of the people, and we have to think about creating such mechanism that is that doesn't exist now. So I think you said there should be, we have to march towards that. There should ultimately police or any agency should be answerable to the public in general and to the representatives of the public, and we should be in a position to create such mechanism. Point one. Point two is that now we talk about other agencies like we can think of as non-governmental organizations or other agencies can be involved in the a process of dealing with the suspects or accused. And police, for example, when they want to take the support of some experts to get to the facts from the accused. So all those things, these agencies can support, but ultimately we should think of creating an alternative system to the existing mechanism of resorting to arrest casually, and it should be also police should consider that as a last resort. Arrest should be the last resort, particularly in property offences, particularly in petty offences. If that restraint is there, that itself will resolve most of the problems. And now that is the problem. Actually, we don't have any mechanism to check that. Suggest that we should create such a micro-level mechanism where arrest should not be the first option, it should be the last option.
Right. Thank you, Dr. Srinivasan. Dr. Surendranath, any concluding thoughts? And also, in specific, could you also address that we have the new criminal laws? A lot has been written about how it does not check police excesses. In fact, it allows a higher duration of police custody. So, do you have concerns about the new laws when it comes to them heightening the risk of custodial torture?
Yeah, I think, of course, as you rightly pointed out, it does seem to allow a longer custody of duration of police custody. And I think the entire rhetoric around the new laws of decolonization is just hollow talk, right? There is no real reconfiguration of the relationship between the police and citizens, and it continues to be a culture of control and suspicion of your own people. And I think if at all one were to think of one good thing, it is that there is that the sanction required for prosecution, right? Which in the earlier laws there was no time limit essentially, but you required sanction for prosecution of a public official, right? So in this context, that provision would be relevant. At least in the new laws, they've seemingly changed it to say that if it is not given within a certain period, that sanction, it will be deemed to have been given, right? So that is an improvement. But overall, I share your concern that it only worsens this relationship of culture of control and violence, and the provision extending police custody is seriously worrying, right? And it really tells a lot that in our post-independence law, the kind of variations we have seen in, or the exceptions that we have created to confessions not being admissible, right? The various statutes in which we have done that, how we have regressively changed bail law, how we have increased durations of police custody. These are all these have worsened in post-independence criminal law legislations, right? Under the garb of special criminal laws. And if you look at the colonial laws on these aspects, it really shows up our post-independence criminal laws for being harsher, for being, in those senses, more colonial than the colonial laws themselves, right? So those are my concerns of the general direction in which we seem to be going with criminal law and criminal procedure.
Right. Thank you, Dr. Surendranath. Thank you, Dr. Srinivasan, so much for joining us today. This was a very insightful discussion.
Thank you. Thank you, Aaratrika. Thanks.
Thank you, Mitch.